Welcome to our fifth video for Learning Game C, Wider Implications of Digital Systems. Today we're going to look at data protection. We have three objectives for today. The first one is to understand the data protection principles. When we use the term principles, this means the rules that have to be followed. We then want to be aware of the use of data on the internet. And finally, we're going to look at how we can understand what intellectual property is and all the key terms that are applied. One main reason it is important that we keep our data safe is to prevent ID theft. ID theft only requires your name, address, and date of birth. And from this basic data, they can impersonate you in taking out loans or applying accounts in your name. If ID theft occurs, you can be left with the bill and they have received the money. This is why they attempt to do it. Therefore, keeping our data secure is important, and laws have changed to support this. In 2018, the Data Protection Act was introduced, and we're going to look at this in the next few slides. You may also have seen in the news that the Protection Act has been updated to the GDPR, and this now has been added to the UK Data Protection Act to mean that any data that has been stored for a significant amount of time, they have to re-request your authorization to keep it. When collecting data, organizations must follow some principles or rules. Some of the rules are quite obvious, such as only collecting the data for a specific purpose. If, for example, you are signing up for Tesco Club Card, the data can only be used for that purpose and cannot be stored by Tesco and used for alternative programs. Also, the data should be kept up to date and accurate. If people move house and you don't know that they have, you could send important information such as bills to the wrong person. And also, you will only collect the data that is specifically needed for your purpose. For example, asking for religion or favourite colours or mother's maiden name. When those pieces of data aren't required for the intention of you're going to use it, then this is keeping data that's not required and therefore can be at risk if stolen. When processing data, there are 6 reasons that are for lawful processing. These are consent, contract, legal obligation, vital interest, public task, or legitimate interest. We're going to look at these with examples on the next slide. You may all be familiar with the consent reason. This is where a person has agreed to their data being used. For example, when completing a questionnaire or survey, you may tick a box at the end to receive information via a newsletter. The second way of lawful processing is through a contract. For example, when you buy a house, the data must be processed to allow each person to move into the house accordingly. Also, there's a legal obligation. For example, when you're keeping tax records, that data needs to be processed to make sure that you are abiding by the laws. The next way of lawful processing is vital interest, and this is if it's to protect somebody's life. For example, a teacher could give a student's name to a paramedic if they've collapsed, so they can talk to them to try to get them to recover. The last 2 are public task, where it may be a criminal court, or legitimate interest, where there's a clear benefit to the user. So if they process customer data and they can then find a benefit to the customer, then obviously that is a beneficial thing and should happen. Now we have collected and processed the data, we get to the next stage, which is data storage. And again, the Data Protection Act places rules or principles on companies using this. We have already looked at keeping data up to date and accurate and the reason for this. But the next set of rules that are in place are quite, again, obvious, but need to be conformed to to allow companies to keep data safe. Things like not keeping data longer than necessary means when you leave school after a set number of years, your data is safely removed. This doesn't mean put into a bin outside and left for people to walk by and pick up, but it does mean that we're not storing data for a long enough time that we no longer require it and are therefore at risk of losing data that's not required. We also must not transfer data outside of the EU. This is because other countries do not follow the same rules and regulations as the European Union companies do, and therefore they may not be obliged to keep data secure in the way that we are. Also, customers must be told of a data breach within 72 hours of it occurring. This has now given individuals rights, so they are aware that their data has been taken and they can ensure that they are not having any consequences, such as if bank details have been taken, customers can check their bank accounts and inform their bank, so then any payments are not paid to unauthorized users. Not only has the Data Protection Act of 2018 put rules in place for businesses keeping data, it's also now given customers or individuals rights. This means you can now contact companies who have your data and have set rights in place by law. For example, you have the right to view data that is stored about you. So you can see what has been written about you, what has been stored, and what has been used by the companies. If you then spot any errors, you also have the right to make changes to the data, because the inaccurate data could have consequences. You also have the right to withdraw your consent. So for example, if you have signed up for a mailing list, but you no longer want to receive those updates, you now have the rights to request that to stop. And you also have the right to be forgotten. So not only can information be stopped sent to you, but this allows you to delete your entire personal data that company has stored on you. Because the Data Protection Act is in place, companies have to follow it. And if there was no penalties to breaking the Act, then companies would not be that concerned. However, there are severe penalties that are in place. And again, you may have seen these in the news, where companies receive large fines or some time in prison for their loss of data. The first penalty for breaching the Data Protection Act may be just a warning to the organisation, or they may order the organisation to follow the principles that have been stated on the previous slides more closely. If the data breach is more severe, for example, all the customers' bank details have been stolen or lost, they may receive a fine. And this fine can be a large amount of money, as shown on the slide. If the companies continue to lose data over the years, there may then also be legal action, where people can suffer time in prison and also a loss of brand image. All this negative publicity of losing customers' details in the press on a yearly basis means that customers are then going to go to your rivals as they don't trust you anymore. We're now going to move on to the next part of the presentation, which is how we protect our information and products. The first method is called intellectual property. And this is where the property is not physical, so you can't touch it, but it has a value. For example, a company's logo. The big M for McDonald's is recognizable for that company. If somebody else just took that logo and started using it for their company, then this would break the intellectual property rule. Also, books and music and videos that are created. If somebody took a part of music, what someone had already created, and used it in their song, this would break the intellectual property rule. We're now going to look at a few more examples of intellectual properties, such as copyright and trademarks. When an individual creates a new product, this is known as an invention. James Dyson recreated the vacuum cleaner into what is known as the Dyson. And when he created this product, he wanted it to be securely only accessible to him and his company so he can get all the customers. This is where patents comes into place. A patent prevents anyone else using your designs of your invention for 20 years, keeping your customers to you rather than your rivals creating the same product. You may have heard of the term copyright. When watching films, it is usually displayed at the start. Copyright also protects books and videos, and typically lasts 70 years, which means people can't take the creation of your music and use it in their own songs. We also have trademarks. You might have seen the little TM next to companies' names. This means that they've been registered as a trademark officially by law. And these trademarks are used by a company so they cannot be used by others. So for example, your company's name can't then be used by another company. For example, Subway is trademarked. So if I open up a sandwich shop and call mine Subway, then they would be able to prosecute me. We also have something called a brand, which is made up of trademarks like your logo, your product names, your business stationery, the colour scheme you use, how it is designed, your company's personality in terms of how it comes across. All those items come together to form your company's brand. And if another company tries to steal that brand, therefore to deceive customers into believing they are part of your company to gain sales, then again, laws are now in place to prevent this. If an individual or companies decide that they're not going to follow the intellectual property rules or copyright and trademark, then they can face consequences. If, for example, you were to take a part of music produced by Ed Sheeran and use that in your own band's track, this would be known as a copyright infringement. And from doing this, you can then be legally prosecuted. And this can lead to two main consequences, such as a large fine or a prison sentence. Now, this doesn't mean that everything that's ever created cannot be used. As you may be aware, if you reference the creator, then you can include part of their work into your coursework at school, for example. This then acknowledges that you're not the creator of that sentence or paragraph, and you're giving credit to the original person. If, however, you copy your entire coursework from a website, this is then going too far. And this is where we have the term plagiarism. If you were to submit a degree coursework assignment in, and all you had done is copied somebody else's work and then pretended it was your own, then you would obviously be prosecuted or thrown out of university. You must acknowledge who created the original work, such as stating their name and the year it was produced. You also need to use quote marks around any text that is copied, so you are quoting what that person has written rather than saying that you are writing it. And if, for example, you were to take a part of a book, such as a couple of pages out of there to take home and revise, or an image to then use in your work, you must gain permission from the owner or author. You may need to pay for a license to use that graphic or work in your work. And again, you need to reference them by acknowledging them as the author or creator in the work that you create. By following these rules, you can then not be prosecuted for breaking the intellectual property rules.